Hello everyone and welcome. My name is Eli Al-Shair. I am the founding attorney and counselor at the law offices of Eli Al-Shair. We are based in Dallas, Texas. And to learn more about our services, please visit us at www.alshair.com. Over the past week or so, I've received so many inquiries from many of you about the meaning of the decision, Dobbs v. Jackson, and its implications, and the overturning of Roe v. Wade. So this is prepared as an answer to all of these questions, and hopefully I'll be able to address all of your questions with a focus specifically on the legal reasoning that the Supreme Court adopted in this decision to overturn Roe. So the talk today will focus on the legal reasoning of the court, the implications of overturning Roe on abortion nationwide, and the impact of this decision on other issues that were decided in a similar manner. For those of you who are not familiar with the history of Roe v. Wade, Roe was a pseudonym. The lady that it was covering basically was Norma McCorvey. She was a single woman living in Dallas, in Texas. She had 2 kids and she was pregnant with a third when she was counseled to have an abortion. The folks who were counseling her, unfortunately, could not help her get the abortion at the time, but did bring a cause of action on her behalf against the district attorney of the county in Dallas in order to declare the Texas criminal abortion statute as unconstitutional. The Texas criminal abortion laws at the time stated specifically that an abortion was illegal except if it was performed to save the life of the mother. Wade was Henry Wade, the district attorney for Dallas County at the time. The case made its course through the courts until it got to the Supreme Court. And the Supreme Court decided then, in Roe v. Wade, that a state criminal abortion law that does not create exceptions for the stage of the pregnancy or other interests and strictly focuses on the health of the mother violates the due process clause of the 14th Amendment, and declared the Texas statute to be unconstitutional. But the court went beyond that. It also declared that abortion was a fundamental right under the Constitution, and a woman had this right to terminate her pregnancy without interference from the state. At the time Roe decided, this was the abortion landscape in the United States. The states in red had declared abortion illegal long time ago, except to save the life of the mother. Many other states, you see them there in blue and yellow, in addition to the exception for the mother's health, had other exceptions like rape, incest, and a likely damaged fetus. Only a handful of states, shown in green, had abortion, elective abortion, legal upon request. Either they did not have regulations for abortion, or their regulations were very permissive. Beyond declaring abortion as a fundamental right, Roe went further and looked at the stages of pregnancy, dividing it into the 3 trimesters, and basically declared law for each one of these trimesters. For example, during the first trimester, an elective abortion must be left. The decision on that must be left to the pregnant mother and her physician. The state could not interfere in regulating abortion in this first trimester. In the 3rd trimester, by contrast, or post-viability, a state's interest may come in, and a state may regulate abortion, post-viability, all the way up to prohibiting it, except where necessary to protect, again, the life of the mother. Now, this Dobbs v. Jackson was not the first review of Roe. Roe was reviewed before. A famous case that reviewed Roe was Casey v. Planned Parenthood of Pennsylvania that was decided in 1992. Although Casey did not overturn Roe, but it said plainly that the Roe court had reached too far in making an analogy between an abortion, the right to abort a fetus, and a fundamental right. It analyzed the historical tradition of the American people as enshrined by the English common law and the American abortion statutes in existence both at the time when the 14th Amendment, upon which Roe was decided, and also all the laws in the states that existed at that time. Neither the 14th Amendment nor state law had articulated a right for abortion. But Casey stopped short of overturning Roe in 92. What does the 14th Amendment, the basis for the Roe decision, says? Basically, it addresses many aspects of citizenship and the rights of citizens, but the most used and frequently litigated phrase in the amendment is the equal protection of the laws. I'm going to quote a paragraph here for you. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without a due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So this was used as a basis to make these decisions in Roe and then later on overturn Roe. The courts have interpreted the 14th Amendment due process to include both a procedural due process and a substantive due process. Both of them were necessary to have what the courts termed the ordered liberty. Ordered liberty basically is a freedom that is limited only by the need to have order in society. What's the difference between these two types of due process? The procedural due process limits state and federal power by requiring certain procedures to be followed in both criminal and civil matters. The state cannot diverge from those, otherwise it violates your rights. For example, the Fourth Amendment right against unlawful search and seizure, your right to a trial by jury, the right to an attorney, the freedom from self-incrimination. All of these are examples of provisions that are central to procedural due process. This procedural due process ensures that you will have your day in court, you will have a fair trial by a jury of your peers, and if any of your rights are violated, you have the right basically to declare a mistrial or to get out the evidence that was entered in violation of due process. The substantive due process, on the other hand, is a legal theory that is based on the premise that the Constitution protects the public in general from an unwarranted government intrusion infringing upon their fundamental rights. So if the government passes a law that infringes on life, on liberty, or on property rights, a substantive due process analysis must be had to find out whether this law is constitutional or unconstitutional. If it violates this Constitution, it will be declared unconstitutional and it will be overruled. The Dobbs v. Jackson case was decided on June 2022, in which the Supreme Court overruled or overturned Roe v. Wade and also overturned Casey. It's a suit against a Mississippi law that banned nearly all abortions after 15 weeks of pregnancy. What does it mean? What does the ruling in Dobbs mean to abortion? Well, it does not mean that abortions now are illegal in the United States. Far from it. That is not the intent of the court, and that is not what was decided. But what the court decided is that the regulation of abortions, declaring whether it's legal or illegal, does not reside within the Supreme Court, but rather with the individual states. It is their right to regulate abortion and decide whether and when an abortion is legal or illegal. The parties to the Dobbs v. Jackson are Thomas Dobbs. He is the state health officer at the Mississippi State Department of Health. His name appears on the case, although he had nothing to do whatsoever with it. But based on his sovereign immunity protections, the plaintiffs must sue the head of the regulatory authority, which in this case is the state health officer. The Jackson is in reference to the Jackson Women's Health. It's a women's health clinic located in a very bright pink building in Jackson, Mississippi, and it has been the only clinic providing abortions in the state of Mississippi since 2006. At issue is the Mississippi Gestational Age Act. Mississippi had passed a law that said, except in a medical emergency or in the case of a severe fetal abnormality, a person may not have an abortion after 15 weeks of pregnancy. So it limited the right to abortion to 15 weeks of pregnancy. The case came up to the lower court, the Federal District Court, and it was reviewed by the Fifth Circuit Court of Appeals, which found that the 15-week restriction on abortion violated the Supreme Court cases that forbid states to ban abortion pre-viability. Those cases are specifically Roe and Casey. Pre-viability regulation of abortion was not allowed. So the ruling from the Supreme Court in Dobbs came and said that the Constitution does not confer a right to abortion. Both Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives. the court conducted a judicial analysis, a constitutional analysis, like it usually does, and looked at both the Constitution and the impact of precedents. First, it found that the Constitution does not confer a right to obtain an abortion. It said that Roe held the abortion right as part of a right to privacy that sprung from the 1st, 4th, 5th, 9th, and 14th Amendment, but the Casey court, which reviewed Roe in 92, grounded its decision solely on the theory that the right was part of a liberty protected strictly by the 14th Amendment due process clause. None of the other amendments were included. What does the 14th Amendment reference to liberty include? Does it include a particular right? The court said no, it does not include a particular right. The due process clause protects two categories of substantive rights. Those rights that are guaranteed by the first 8 amendments, Amendment 1, which is the freedom of expression, all the way down to Amendment 8, and those rights that are deemed fundamental but are not mentioned anywhere in the Constitution. Well, how do we decide, which rights are fundamental? They have to fall in either of these categories. So the question is, do these rights, are they deeply rooted in our history as a nation and our tradition? And are they essential to this nation's notion of ordered liberty? If they are, then they do fall in one or the other of the categories, and therefore they become a fundamental right and they are protected by the Constitution. The court found that the right to abortion is not deeply rooted in the nation's history, and for that it conducted a very thorough analysis, and it fell back also on the analysis that was conducted by Casey. Until the latter part of the 20th century, there was no support whatsoever in American law for a constitutional right to an abortion. It went back also to what Casey said. By the time the 14th Amendment was adopted, 3/4 of the states had made abortion a crime at any stage of pregnancy. And this consensus endured all the way until Roe was decided. So definitely it is not part of the history of the nation. The court went further and said that in interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberty that Americans should enjoy. So regardless of what the justices may think, regardless of what the public may think, the court's job is not to tell us what a liberty is. It is simply to interpret the Constitution and tell us whether it falls within those constitutional protections or not. The court said that Roe either ignored or misstated this history, and Casey declined to reconsider this faulty historical analysis. The third prong in the constitutional analysis was the attempt to justify abortion through appeals to a broader right to autonomy and to define one's personal concept of existence. The court found that to be too much. The court, in fact, said that those criteria at a high level of generality, if we were to adopt this view, we could then license fundamental rights to illicit drugs, fundamental rights to prostitution, and the likes, things that are not part of our society. The second step in the constitutional analysis was whether the doctrine of stare decisis, precedence control, compels the court to keep Roe as part of its history. The court found that stare decisis does not counsel continued acceptance of Roe and Casey. Stare decisis, for those of you who are not familiar with it, means that precedent controls. It's important because it usually saves parties and courts the expense of endless litigation, but the court found it to be not an inexorable command. It can be challenged. And the courts identified 5 factors that must be looked into in order to decide whether a precedent should remain or be overturned. The first one is the nature of the prior court's error. In this particular instance, the Dobbs court found that Roe and Casey called on both sides of the national controversy to resolve their debate. But in doing so, they declared a priori a winning side. Those who are on the losing side of the Roe and Casey decision could no longer seek to persuade their elected representatives to change the law. That's it for them. In other words, the Supreme Court short-circuited the democratic process by closing it to a large number of Americans who disagreed with Roe. The second prong in the stare decisis analysis was the quality of the reasoning of the Roe and Casey courts. And the Dobbs court said that without any grounding in the constitutional text, history, or precedent, Roe imposed on the entire country a detailed set of rules for pregnancy divided into trimesters, much like those that one might expect to find in a statute or a regulation. This fact-finding process is a consideration that is usually taken by legislative bodies, not by courts. In the US, the job of the Supreme Court is to evaluate the constitutionality of the law, not to make the law. The laws are made by the legislative, the federal Congress or the Congresses of the state, not by the court. The court simply tests the constitutionality of the law and decides on it. The scheme in Roe produced looked more like a legislation, and the court provided the sort of explanation that one might expect from a legislative body. In fact, when Casey revisited Roe almost 20 years later, it reaffirmed Roe's central holding, true, but it pointedly refrained from endorsing most of the reasoning in Roe. The third prong was workability. Was the decision in Roe and Casey workable? Did it make it easy on the lower courts and on the courts of appeal to actually handle these decisions and decide on challenges that came before them? And the court found that, in fact, no. It scored poorly on workability. So it was not a good precedent. Furthermore, in terms of its effect on other laws, Roe and Casey have led to a distortion of many important but unrelated legal doctrines decided on different cases. And finally, in terms of deciding whether stare decisis should keep Roe and Casey, the court looked at reliance interests. Overruling Roe and Casey will not upend concrete reliance interests like those that are found in cases involving property or contract. The court reasoned that abortion is generally an unplanned activity. You do not get pregnant in reliance on the fact that you have the right to an abortion, and reproductive planning could take into consideration a sudden change in the law. So based on these 5 factors, the court decided that stare decisis in this particular case is not an inexorable command. In addition to the constitutional analysis and the analysis of stare decisis, the court looked at 3 other factors. One of them is the danger that the public will perceive a decision overruling a controversial decision such as Roe as influenced by political considerations or public opinion. The court warned against that. It said that it cannot allow its decisions to be affected by such extraneous concerns, and it must be strictly focused on the Constitution and the law. The court went on to further declare or reaffirm that the basis for review or the standard for review for any case of abortion is the rational basis. The rational basis basically gives the states the right to regulate abortion for legitimate reasons. So any future case that may come up before the Supreme Court in relation to abortion will be reviewed on a rational basis standard. And finally, the court declared that abortion is a profound moral question, that it was not going to get into it. So the morality or lack thereof of an abortion was not a business of the court to decide, and it was best left to the citizens and their representatives to decide on that, not the courts. So what is the impact of this decision practically? First of all, abortion is no longer a protected constitutional right. So you may hear some politicians refer to it as a constitutional right. It's no longer the case. It is now a healthcare issue like any other healthcare issue that could be regulated by the states or by the federal government if it chooses to do so. If the federal government tomorrow chooses to codify what was into Roe, it can do so if it has the votes. So different states now have different laws on abortion. Some states do not regulate it at all. This means that, elective abortion or abortion at will is legal. Others ban it altogether except to save the life of the mother. And this is what the map of the United States today look like. It's an evolving map that may change soon. In green, you have the states where abortion is legal. In the color tan, you have states where there is currently no ban, but abortion may soon be regulated. In orange, you have states where there is a triggered restriction on abortion, and we're going to see what that means when we look at Texas in the next slide. And in red, you have states that restrict abortions except to save the life of the mother. So Texas has what we call a trigger law. This means that there is a law on the books in Texas, but it will go into effect in the coming weeks. It was triggered by the overruling of Roe v. Wade. the law bans all abortions from the moment of fertilization, except in rare cases to save the life of a pregnant patient or to prevent substantial impairment of major bodily functions. Furthermore, it has a proviso that makes anyone who assists in an abortion, whether it's an anesthesiologist or someone providing medicine strictly for that purpose, they could be charged in the same charge. So what are the immediate implications for other Supreme Court decisions? According to the Court's opinion, nothing in the Dobbs v. Jackson decision should be understood to cast doubt on precedents that do not concern abortion. So this decision is restricted strictly to cases on abortion. Right of married persons to obtain contraceptives under Griswold, right to engage in private consensual acts under Lawrence, and right to same-sex marriage under Obergefell are currently not at issue, and this case does not touch upon them at all. However, we must look at the concurring opinion by Justice Clarence Thomas. Justice Thomas says clearly that in future cases, we should reconsider all this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Because any substantive due process decision is demonstrably erroneous, according to Thomas, we have a duty to correct the error established in those precedents. So if any case should in the future come up before the court on same-sex marriages, on the right to engage in specific sexual acts, etc., the court may review it with the same reasoning that it reviewed Roe v. Wade and may overrule it. We have no certainty in that sense. If you have any questions, please feel free to reach out to us via the website, email, or phone number. And finally, if you liked this presentation, please hit the like button, subscribe to our channel, and invite your friends to do the same. Thank you.